Well, good morning, everybody. And well, good morning here, but good day. I'm sure different time of the day for everybody around the world. And those who are in the US, well, of course, good morning as well. Today, again, welcome back to the Purdue CIB seminar series that we have been conducting this semester. And we have very distinguished speaker today, and that is Professor Andrew Agapiou. But before I introduce him, we also have Professor Theo Haupt and his wife Ariel here with us. They're physically visiting Purdue campus as well. So we are indeed full of dignitaries at the moment. So let me give a quick introduction to Professor Agapiou before I hand it over to him. And Professor Agapiou combines his academic background in construction law and mediation with over 25 years of industrial experience helping clients to manage and resolve their disputes. As associate professor, Professor Agapiou leads the construction law research cluster at University of Strathclyde and has written numerous articles dealing with the legalities of the construction process. He is also coordinator of W113, which is Law and Dispute Resolution Working Commission for the CIB, which, as you all probably know, is the International Council for Research and Innovation in Building and Construction. He has published his research monographs on court-connected construction mediation practice and alternate dispute resolution in the construction industry. Professor Agapiou is a certified mediator, and he specializes in commercial and in-court mediation. And today, let me hand it over to him to introduce the seminar and take it from there. Andrew.
Thank you, Mark. Thank you. Much appreciated. And hello, everyone. Good morning. I hope you're all having a good day. So just to follow on from the introduction, I'm honoured to have the opportunity to speak to you all, to present a little slice, a little taster of some of the work that I've been doing for the past 10 or so years. I'll go through the genesis of the work, what progress we've made over time, and where we are now. Hopefully providing us with an opportunity at the end to discuss and for me to answer any questions. So I'll kick off with the slide presentation. Just want to say a brief few words about the CIB and the CIB W113 Working Commission. I'm not going to read anything out, but simply to say that the Working Commission in Law and Dispute Resolution has been very active over the years. Certainly has undertaken significant work, and are happy to be involved and have been leading the Working Commission for about 6 or 7 years and coordinating a number of research projects. Many further details of the Working Commission can be found on the CIB website. Just to give you a kind of a flavour of the types of work, the types of task groups that have emerged out of the 113's activities. Some are focused on very technical areas, such as building regulation and control in context of climate change. Others have related to the use of advanced technologies, such as BIM, in the legal sphere. And the latest work, which came to an end just before the COVID period, focused on construction mediation practice. And that was an international review which I led with colleagues from South Africa, US, Hong Kong, and Turkey, including some work published from the English jurisdiction. So that's a brief overview of some of the work that's been undertaken. Things have moved on since the TG89 work was completed, and I'm now looking at the application of the digital technologies in this area of dispute resolution. So look out for some of that work that's coming out in the near future. Right, so I thought I'd maybe just start with an introduction to myself and then set the scene for the session. So what can I say? What can I add to Mark's great introduction to the session? Coming from a technical background, graduating in the building design, building technology area, first experience of law and dispute resolution came more or less in my first position. So I worked in industry for a number of years before becoming an academic faculty member. And one of my initial positions was as a contract administrator. So that really set the scene for a passion, something I've been working on for the past 25, 30 years. And that led to, the interest led to requalifying, some additional study, master's, PhD level, and then on to research and developing and leading a research program in construction law. So this is just a couple of examples which Mark had mentioned earlier. So 2016, with a colleague from Istanbul Technical University, we published a monograph, a comparative international review of court-connected construction mediation practice. And very recently, indeed last month, was my book came out. So this is the book on the right-hand side, ADR in the construction industry and evaluation of UK research and practice. So that book, this recent publication, really brings together my research activities looking at alternative dispute resolution, but also my practice experience. So I've been a mediator, certified mediator, probably for about 10 to 11 years now. So I thought I'd maybe reflect on that experience by bringing together some of the research and some of my practice experiences in one very short volume, which is available for purchase. Like all academics, we love to plug our own research and especially books. So very generously, I've in one of the slides towards the end, there's a 33% discount on anybody that's interested. So I've put the QR code up there. So if anyone is interested, please also make contact. I appreciate having a discussion with you on my work. So this work really began in 2010. At that point, I was finishing my master's degree in construction law and arbitration, and wanted to look at, because I've become aware during the course of my studies that while alternative dispute resolution did exist, it wasn't clear why it wasn't being promulgated within the industry. So I wanted to understand, given that I was living in Scotland at the time, what was the experience of the legal profession? Did they have any awareness? Were they engaged with alternative dispute resolution in its broadest form? Were they gatekeepers, which is something that we wanted to look at in a bit more detail. And also, in addition to that, how clients, and when I say clients in this case, I'm talking about building sponsors, owners, etc., rather than the individual clients of legal practitioners. That emerged into studies looking at the role and experience of mediators themselves, and following that, we're starting to look at how mediation is used in planning disputes. So it's quite an evolution that took place in terms of the research itself. And it was really interesting to be undertaking this type of research while being a practitioner. Because things that I picked up in the research helped me understand the process, but also things that I experienced in practice helped me develop the research further. So, and I think that's something really powerful that the CIB provides, this interface that's possible between the practitioner and the researcher. So it's almost a great selling point for CIB in general. So I'm not going to go through every single slide in a great deal of detail. I'm just going to take a canter through some of the context of the work, talk about the approach, highlight some of the results, talk about the future, and then hopefully answer a few questions. Certainly, we look at the industry itself. There are a number of issues that differentiate the industry from other parts of the economy. The adversarial nature of contract, the power imbalances that exist within industry, the practices adopted by parties, sometimes confrontational, can lead to disputes. On the other hand, what we do know is as the industry has evolved over time, there's been moved towards new methods of working, which are largely collaborative in nature. Partnering, alliancing, joint ventures, and indeed the way that the contracts have evolved over time, the FIDIC contracts, the NEC 3 and 4 contracts, and so on, they've evolved to take into account the evolving nature of how parties interact and how they're moving towards more consensual ways of dealing with problems as they arise. So they're much more project management focused than they used to be. So one of the questions I wanted to look at in my research more broadly is it nature or is it nurture? What is it nature of the industry that leads to disputes, or are disputes nurtured simply because of the industry culture? So that was a key research question I had right at the beginning of my work. Other aspects of the industry, technically complex, multi-party arrangements, very international. All this gives rise to the potential for disputes to occur. In setting out my stall and my proposition for the research in general, and in developing the work of the CIB W113, I think it's just important just to set the scene and talk about what ADR is. So what is alternative dispute resolution? It's a range, it's a spectrum of different approaches to the resolution of disputes, which vary from a very simple one-to-one negotiation right through to early neutral evaluation. So what we can say is from mediation onwards, a third party is involved in some way. Those in the US will be familiar with dispute resolution boards. Others may know them as dispute avoidance boards or dispute adjudication boards. And then increasingly, those arrangements, those bodies are becoming increasingly embedded now in many international contracts. I'd like to characterize ADR or mediation along a continuum in terms of level of control. So the level of control against third-party intervention. What we can say is that the industry as a whole and across the world is moving away from using litigation. And that's happening parallel to the moves away from adversarial culture and adversarial ways of working to more of a collaborative approach to delivering projects. And what goes with that hand in hand is a more consensual way of dealing with differences and therefore dealing with disputes. So degrees of control and also hostility arise as we move away from consensual approaches and also towards more third-party intervention. So third-party intervention ultimately leads to the courts or to adjudication or arbitration, whereas the language of ADR as it exists now is much more focused on mediation, conciliation, and negotiation. So there's an emerging language. I'd like to talk about the language of ADR as evolving. And certainly much of the writings that you'll see about ADR are specifically focused on mediation itself, rather than any other forms of alternative dispute resolution. So a little bit of the background. So how did I get into this? Having completed my academic work in Scotland, I was interested in taking that forward through my dissertation work and really trying to understand why mediation, why ADR wasn't taking off. At the same time, I recognize and acknowledge that at that stage in the work, and this is going back 11 or 12 years, little had been written or little had been known about lawyers' interaction with the process itself. But also critically, and this is an aspect I'm still working on, so this is a labor of love as much as anything else, is establishing baseline knowledge. So being one of the first to do and undertake this type of work within Scotland, and for those who don't know, Scotland has its own jurisdiction, its own law, its own parliament, and indeed some aspects of the law in Scotland diverges from the English approach. And that's an important issue that I'll touch on as I go through the discussion and present some of the findings. So that's a bit about the background. Now, this set of slides just provides a little bit of the context of how the Scottish context appeared at the time. And indeed, what I can say is matters have moved on since I started the research to a point where the Scottish government and Scottish Parliament are starting to think about introducing mediation into the legal system. Now, that this is quite a controversial point for many legal scholars. One of the central tenets of mediation is consensus and entering the process with consent. So the introduction of mediation into law, or through judicializing the process, or developing the institutional framework or scaffolding for mediation to take off, is quite controversial. It takes away the consensus that is at the very heart of what mediation is. So I'm somewhat skeptical about the approach being followed, and indeed the situation in England is somewhat different. There's no call or demand from government, the courts, the legal profession, or indeed the construction industry to move towards mandating mediation in English law. So this will be an interesting area for me to explore in the future, and also to share experience with others of maybe living or based in countries that do have mandated mediation in their legal systems. At the beginning of my work, I really wanted to understand something about the numbers, something around the studies that had been undertaken previous to my work, the work done at Strathclyde. So numbers were views of participants, and there'd been a number of different studies done over time, mainly in the 1990s, mid-1990s to the 2000s, looking at opinion, the perceptions of parties. The baseline information at that stage pointed it simply in one direction, that parties really hadn't much experience or had not used mediation to a large extent, but the picture was unclear. One study said this, another study said that. So in addition to trying to compile the data, the hard data on how much mediation was being used, I was also interested in understanding the perception of parties and whether indeed there was any gatekeeping going on in the use of alternative dispute resolution methods. So was it something to do with the lawyers? Was there some resistance within the industry? Was it the nature of the industry? If that was the case, the picture was unclear. So one of the early findings that we identified, and this is my colleague from Newcastle University, we identified approximately 2/3 of respondents when we spoke first by starting speaking to lawyers did have some experience of representing parties in one case. What we did understand very quickly from doing the work is that there was a marked divergence in how mediation was being used north and south of Hadrian's Wall. Hadrian's Wall, for those uninitiated in UK geography, is the border between England and Scotland. So, having looked at the figures and noticed the differences between the two UK nations, we wanted to understand why that was the case. Was it something to do with the nature of the legal profession, the differences in education training around ADR? Was it something to do with the types of projects? What were the factors and characteristics of the industry in Scotland that militated against the use of mediation to resolve disputes? What was going on? Now, having set the scene and looked at the numbers, the differences between England and Scotland, we wanted to then look at the framework, the legal framework that sits around certainly the promotion of ADR in this case, or the promotion of mediation, and whether that was a key factor in promoting ADR in the two different UK nations. One of the things that we identified very early on is that in England, the picture was different. And indeed, there had been several key legislative changes that had been introduced in England, such as the Civil Procedure Act in 1996, which led on to the development of the Civil Procedural Rules in 1997, which came from the Wolf Review, and then the subsequent court cases, which emerged from the application of CPR in the English technical and construction court settings. So in England and Wales, there are separate courts that deal with construction cases. These have not spread north of Hadrian's Wall, and indeed much of the cases related to construction are either in the inner court or the outer court, sometimes in the commercial courts in Scotland. So the picture was telling us things were more advanced in England as compared with Scotland, and indeed the case law had advanced. Horsey v. Milton Keynes NHS Trust was one of the first ones which we noted in our literature case law review section. Other cases which emerged following that go from 2005 on to 2013, and indeed in my book here, charted further cases on from 2013 up to more or less the present day. So there looks like there's a lot of activity around alternative dispute resolution and the use of mediation. And certainly the judges in the TCC courts are promoting it to parties. Ultimately, we don't know where this is going to go, but indeed, what we do know is that the courts are certainly promoting its use. In Scotland, the picture's somewhat different. And although there's been progress, which I've mentioned already, there wasn't much movement until the Gill Review in 2010. So the Gill Review was equivalent to the Wolf Review that was undertaken in England in the mid-1990s. That didn't mandate or point the way to the development of any rules, such as the CPR rules in England, but certainly promoted the wider use of mediation, certainly, and the promotion of its use to resolve disputes. That has moved on, and this slide captures the situation at the time, the turn of the 2000s into the 2010s onwards, up to the point, and this is again a significant point, a milestone that we're reaching, is the consideration of the introduction of mediation as a process into the Scottish legislative framework. And indeed, what's quite interesting, and it's something, having signposted it already in one of the earlier slides, is in the new planning legislation in Scotland, they introduced an amendment which allows parties to resolve disputes in the planning arena. And that's really where my work is just now, where one or two new PhD students are starting to look at this under my direction. So it's exciting times. There's a lot of scope to develop this work further, and I look forward to work with others of a like mind. So picking up my work from Professor Clark at Newcastle, what I wanted to do is understand whether attitudes, the legal profession, the absence of an alternative resolution certification or registration body, and indeed the lack of client awareness, were factors that were limiting the demand for mediation in the Scottish construction industry. So a framework was available, therefore, for me to build upon in terms of taking my work forward, but also building on it. It seems that looking at the previous studies done elsewhere, lawyers seem to be gatekeepers to the process. And certainly looking at the English context suggests that that was indeed the case. So I wanted to understand, was the legal profession in Scotland, were they thinking along the same lines? Were there any inherent differences, or did opinion diverge? So there'd been a growing body of research previous to mine that led to lawyers' perception around mediation and how they used it. So certainly much of the work before the 113 programme had picked up this as an issue, the gatekeeping that goes on. And certainly I wanted to delve into that and understand, was that the case for the industry, for the construction industry in Scotland? And it seems, yes, indeed, that lawyers were the gatekeepers. Parties, disputants, I should say, therefore, weren't able to exercise agency in the selection of dispute resolution methods. Now, possibly and probably the industry culture, the adversarial nature of construction itself, also leads us to that same conclusion. But it also suggests that perhaps parties, disputants, had no knowledge of the process itself, and during discussions with their legal counsel, perhaps alternative methods weren't part of the conversation. Again, we wanted to look at and understand why that was, and what are the factors that led into the gatekeeping of the processes. So when we spoke to lawyers, and we spoke to quite a range of lawyers and surveyed them in different ways, 5 things really stuck out in terms of findings. Lack of knowledge or familiarity with mediation or any other form of alternative dispute resolution was a clear factor. Attitudes and perceptions, negative experiences, probably one of the key ones, I would say, and this kind of makes sense to me and probably to others. Litigation can be very costly, and lawyers or the legal profession live through fees. So like 1 + 2 or night follows day, a longer process leads to higher fees. Certainly when a court, in a court context. Mediation, on the other hand, is something that's meant to be low cost, speedy, and easy to process. One of the other factors we had quickly identified in terms of barriers was how the courts were involved in promoting ADR or mediation. And certainly what I'm picking up from looking at the technology and construction court cases, the case law review, which I completed recently, and also the direction of travel in the Scottish arena, is that more judges in Scotland at the in the smaller courts, we call them sheriffs, are pushing parties to mediate. And this has created many opportunities for both practitioners and researchers to follow up. In parallel to the Scottish work, I started looking at the English context. So I thought it was interesting just to do some compare and contrast, simply because given the nature of the process, mediation is a private process. There are no baseline figures there. There's no central body that collects statistics on mediation or ADR. And I thought it useful just to see how things are developed in England following the work done by Brooker and Lovers in mid-90s onwards, by doing a parallel study comparing the experiences between the English lawyers and the English disputants and those in Scotland. And what I was picking up, some interesting findings were the small pool of mediators in the UK as a whole. If you look at some of the statistics that are collated and collected by bodies such as a Civil Mediation Council, so that's the organisation that represents the English mediation practitioners, the lobby group, if you like. They collect statistics, and what they identify is that within England itself, the pool of mediators is quite small. The other factors which seem to lead lawyers into not promoting ADR or mediation to resolve disputes, again, seem to be the negative experiences. preferences for other forms of dispute resolution, and of course, the financial interests. So that seems to be a parallel, seems to be common factors between the English context, but also the context in Scotland. Things move on, and in writing my latest book, I picked up changes which are taking place within the industry, which are leading us into a very positive direction. Collaborative working, the introduction of dispute avoidance adjudication boards or dispute resolution boards, the project management focus of NEC4 contracts, the introduction of conflict avoidance boards, which is starting to take off really in the UK for public sector projects. Certainly the earlier experience from the Olympic Games in 2012 in London has led on to the promotion of conflict avoidance and conflict avoidance panels in many large projects. HS2, some of the nuclear power station projects now have bodies such as conflict avoidance panels, central to helping parties resolve their disputes or their differences at the project level. So things are kind of moving in one direction in the industry, which is all very positive. And certainly in the law, things seem to be moving again in that direction. And certainly in England, the courts seem to be promoting a facilitative approach towards ADR or mediation. So one of the issues around that and around its promotion is the whole issue around consent, the private nature of some of these ways of resolving disputes. So it's inherently a contradiction to make something which is consensual institutionalized or judicialized. So this is the theoretical legal scholar debate that's going on just now. And this is hopefully something that I'll start researching next. So just returning to some of the research done and looking at the building sponsor or the client in this case, having picked up what lawyers are saying, we wanted to understand what the clients were thinking. What were the building sponsors thinking? So we spoke to a number of main general contractors, subcontractors, about their experiences of mediation. Were they aware of it? Was it being promoted to them when they had disputes? And so on. It seemed that just in the same way that lawyers had little knowledge of mediation, this is also reflected amongst certainly the larger commercial building sponsors we spoke to. Even though many of them had engaged with large corporate clients, it was interesting to understand that some of them were completely unfamiliar with the terminology. And it's possibly because the way that contracts are constructed, whether it be the local contracts that we use in the UK, JCT, or the SBCC contracts, that stipulate default dispute resolution mechanisms. So some of you will be aware of statutory adjudication and its development in UK through the various legislation, how the Michael Latham report and the introduction of the Housing Grants Construction Regeneration Act in 1996, from which developed statutory adjudication. Now, statutory adjudication is not ADR. It's not even a dispute resolution mechanism. It's there to speed up cash flow in the process, a quick and dirty way of getting parties in a disagreement to iron out differences, which can be challenged and considered at the end of a project. So was it that? Was it statutory adjudication that had been impeding the use of ADR? Again, we wanted to understand if that was a factor. So was contract a factor? Was the default mechanisms a factor in understanding the promotion of mediation or not? So lots of government reviews have taken place since 2001 and 2019 and 2009 in Scotland, and that has led it to the point where there's consideration for introducing mediation into legislation. So watch this space. Okay. What we can, so what I picked up when I was doing the international work, so I looked at the cases in the US and South Africa and Hong Kong and England and Scotland, certainly was picking up a trend that increasingly many countries have started to introduce mandated mediation practice. So that's an interesting area for further inquiry. And certainly the way it's now being approached in the UK, both in England and Scotland, is to push disputants towards ADR and mediation, and provide a penalty for those unwilling to consider it as an alternative. So certainly the English courts and indeed Scottish courts are starting to push parties towards a stepped process. Step meaning go away and try and mediate the dispute before you come back to the court. And certainly that's a trend which we start to see in different jurisdictions. Right, so get into the research itself, and I just maybe start and go through this really quickly. Awareness, interest, concerns around the mediation is something we wanted to pick up, both from lawyers and clients and building sponsors. Views and opinions, based on a very simple explanatory method, survey followed by a program of interviews, understand perceptions, follow up interviews with different parties to arrive at a set of conclusions. So the work was sponsored by the Royal Institute of Chartered Surveyors and the Scottish Building Federation, which represented the building sponsor. So knowledge-wise, there was awareness, not as much as we thought. On the client side or the building sponsor side, less awareness. People seemed to be unaware of what was available to them to resolve disputes. Education seemed to be a factor, both for lawyers, so what was going on in law schools, but also, again, what was going on in construction management schools architecture schools in terms of training and education around different ways of resolving disagreements and disputes. Policy-wise, many firms we spoke to on the building sponsor side didn't seem to have a policy around ways of resolving disputes. Much of it seemed to be led by the contract. What does it say in the contract? Big element of the study was trying to track the mediation cases. Difficulties with this is it's not in the public domain, and therefore we wanted to build up a knowledge base on numbers which were taking place. And indeed, there is no central body, either in England or Scotland, that keeps this kind of data. We have a Centre for Evaluation and Dispute Resolution, CEDA. I may have got the wording incorrect, but CEDA does collect some data, but doesn't disaggregate it by profession or industry and so on. When we spoke to, I'll jump to mediators now, given we're short of time. We also wanted to speak to the mediators themselves to find out what was going on. What type of disputes were they involved in? What did they think about mediation as a process? Indeed, did they prefer a facilitative approach or an evaluative approach? Now, something that seems to be really clear from the English courts is that English courts tend to be promoted a facilitative approach to mediation, which is quite interesting. The industry itself actually is looking for something else. The industry are telling us they're looking for evaluative mediation, which suggests something about the type of mediation or type of mediators that the industry is looking for. More expertise in construction rather than expertise necessarily in the mediation process. Okay, and that just brings me to conclusions, which hopefully brings us more or less to the end. So, when used very well, mediation was successful. Certainly, building sponsors or clients found it really useful. Lots of evidence, some evidence of resistance by lawyers. It seemed that those who are more experienced in the legal profession seem to promote mediation more than less experienced lawyers. Something needs to be done around fee scales, standardizing the fee income generated from using ADR. Broad agreement between lawyers and end users on ignorance and negativity around its use in the construction sector. And certainly there's a role to play for promotion of ADR and mediation in particular within the industry. So that's really everything I wanted to cover. I've put a link at the bottom of this slide under Q&A. That's a link to the latest spring newsletter, spring 2023 newsletter, about all the work that's going on in W113. And the next slide, after key publications, is this. This is a crucial slide, I think, for anyone that's interested in reading a little bit more about my evaluation of really what I've lived in the past 12 years, both academically and in practice. And that's really everything from me, Mark.
Great. Sorry, finish your sentence.
Yeah, I was going to say thanks very much, everybody, for listening, being here today, and I'm happy to take any questions.
Thank you very much, Mr. Agapiou. That was indeed a very interesting, very fascinating overview of dispute and ADR process in UK and Scotland. And of course, raises a lot of questions, I'm sure, around the world. So let me open for Q&A. We have a question right here. Professor Widener is with me in the conference room. I'm going to point it. There we go.
Hello there.
Thank you. It's very interesting, and I've been on two sides of the situation as an expert witness in an alternative dispute resolution and also as an owner's rep. And while I agree with all of your conclusions, I wonder, it's frequently, even though an owner will require mediation and alternative dispute resolution, they frequently also want to know if the parties that they're getting ready to enter into a contract with have had any legal disputes in the past. And at least in the United States, alternative dispute resolution is not something that they can find out about, in which case they frequently end up entering into a contract that will get them into alternative dispute resolution rather than avoiding a contract, which would avoid a dispute. How do you solve that in Scotland?
Oh, that's an interesting question. I think just like you were saying, like many of the options available, negotiation, conciliation, or indeed expert evaluation, mediation itself is a private process. Therefore, it's very difficult to uncover, indeed, has a party ever been involved in a mediation? And therefore, and even if that's uncovered, how did it progress? Now, funnily, I use a Scottish word there, many parties, disputants, use mediation, not necessarily to resolve a dispute, but for discovery purposes. They want to find out what the other party has in terms of figures around quantum, etc. So there's a very, very tactical approach taken by some parties around using some of these dispute resolution methods. There's no easy answer to that in terms of how it can be overcome, but then when we spoke to, and when we do speak to different parties on both sides, they like the look and feel of mediation, but a bit wary about the enforceability. So that's one of the drawbacks of lots of the non-adjudicative methods, is the enforceability of the agreement. Parties can simply walk away, but then other factors come to play, such as preserving the working relationship, the low cost of using mediation and ADR. And I think that's its advantage. Certainly the two advantages that I can see: preservation of relationship, low cost, staying out of the court system. So not a tricky question to ask, but I don't think it's any different else in Scotland than it is in the US.
Okay. Thank you.
Yeah, thanks, Andrew. And thanks, Ted, for that question. Any other questions? Please open your mic and ask questions if you have. Well, so while you're thinking about it, let me throw in my question. And very, very interesting. A lot of good data that you were sharing. A question that was coming to my mind was that, in UK and Scotland, in your research, and what percentage of cases are going for ADR? And also the second part of that question is, you touched upon the cost and saving of time, etc. Has your research pointed of the percentage savings in cost if it were to go to ADR versus litigation?
Yeah. So Mark, there's a classic English saying, "How long is a piece of string?" Yeah. So yes, cost. I mean, certainly we know that ADR and mediation costs less than going to court. That's a very clear message that we get. We know that there are a small pool of mediators in the UK which tend to be involved in the construction mediation cases. Their costs vary. It very much depends on the esteem and the value of project. How much is saved? If you think about the cost of going to court, time taken by parties, disputants. So whereas a case could cost several hundreds of £1,000s sterling, or maybe into 6 figures, mediation may cost £20,000 in terms of fees. So, it's quite an interesting issue. It's difficult to quantify because none of the ADR numbers are in the public domain. So we're trying to, part of the research is trying to plug the gaps in the knowledge, including the numbers.
Yeah, that is indeed interesting. Just a follow-up question, as I don't see any other hands going up yet, is you also mentioned about absence of good mediators in UK, and I was wondering if is there a need for or a requirement for legal training to be a civil mediator in UK?
Well, that's quite interesting. What I picked up when I was writing my book, and the book combines the practice element of my work plus the research element of my work, my academic work. So what I'm picking up and identifying is that because mediation is moving in a certain direction, it's becoming more institutionalized or more judicialized as a process. And that's the way that courts are pushing it. They're pushing it into the lap of the lawyer. So I don't necessarily think that you need to have legal training to be a mediator, but that's one opinion. Others feel differently. But what we picked up when we were speaking to mediators themselves and the construction mediators, 2 central messages came across. The parties that they deal with preferred evaluative approaches. So a mediator will sit down with the individual's parties' viewpoints and evaluate the case. But the court's system pushes parties in the other direction, into the facilitative approach to mediation, which doesn't require any expertise in the industry area. So industry is saying one thing, courts are saying another thing.
Yeah. No, in the US, for civil mediation, we require that you have legal training and also 40 hours of training, etc., about mediation. I think Theo has a question. Theo, hold on one second.
Thank you for a very interesting presentation. Hi. Forgive me if you may have made reference to it. I'm just trying to understand whether the standard forms of contract could be used to enforce mediation and ADR rather than going the normal legal route. If
Yeah.
that was written into that agreement and
Yeah.
then signed, is that possible?
So certainly what's written to some standard form contracts is a dispute resolution process. So increasingly what we're finding is the promotion of a multi-tiered process. So you start off with conciliation, you work towards an agreement, either through that or one-to-one negotiation, then mediation, or maybe a hybrid form of mediation with arbitration, MED-ARB, before proceeding to the court. So certainly increasingly contracts are moving in that direction. And there's many jurisdictions where that's written into the contract itself, this step-by-step approach to resolving disputes. But what I'm finding also is increasingly contracts such as the FIDIC contracts. So if you look at the FIDIC, the latest version of the FIDIC Red Book, it's promoting the dispute avoidance boards much more than many other international contracts. And that might be the direction of travel, but also the conflict avoidance panels. So these, something seems to be going on in this contractually in the development of new contracts. So the multi-tiered processes or multi-tiered arrangements seem to be going in to resolve disputes, but in parallel, there seems to be more focus on conflict avoidance, which is quite an interesting kind of take on things and how things are developing internationally.
Right, yeah. Thanks, Theo, for that question. Any other questions from the audience? Please open your mic and ask questions. Well, let me throw in my next question then, which is, more and more what we are finding is that we recently finished a research with CII looking at the workforce of 2030.
Yeah.
And what came out was that much of the workforce is going to be, or much of the work is going to go off-site.
Yeah.
So more factory build, modularization, that type of effort. So from your research, do you anticipate that is likely to lead to more disputes, litigation, or
Yeah.
and if so, what could be, like Theo's point, contractually could be?
So indeed, some of the other research which I've done more recently is looking at developing a legal framework for off-site construction, and some of that work is in the public domain already. And again, that was sponsored by the RICS. So certainly there's a need to develop a legal contractual framework to address the way the industry is moving. More interfaces is naturally going to create potential for more disputes.
Yeah.
But certainly new methods of delivery may require completely different contractual arrangements than we're used to. And certainly that's going to open up potentially more disputes, but maybe around different areas. But that's where I think the industry is just now. We simply don't know until we develop the frameworks. And indeed, there are some framework type contracts that are now being developed. So NEC4 is quite a good model for use in offsite construction for offsite construction purposes. So anything like that, any sort of framework type, alliance in type of contracts are certainly going to limit the degree of disputes that would arise in an individual offsite type construction project.
Yeah, indeed. Well, in the interest of time, I know there are plenty of other questions that on this particular topic, but we already exceeded by about, I think, 25-26 minutes of our allocated time. So I should let the people go. But before you all go, so first of all, I want to thank all of you for hanging in there. And yes, we have exceeded the time. But as Professor Agapiou mentioned, he has several good books out there. And I think the QR code was there, information at the end of it. And I will ask Professor Agapiou to send me that information also. And if you're interested, we'll have it posted on our website and also the CIB website. So with that said, please give Professor Agapiou a big round of applause. At least now you can open your mics and give a physical applause.
Thank you, everybody. Thank you.
Thank you
Thank
very
you.
much.
Thank you. Thanks, Mark. Thank you. Good to see everybody there.
See you all.
See you
Bye.
later. Bye.
That's always a minefield.
Yeah.
And what I was wondering was,